Hello and welcome back. This is a short video on conflicts of interest and duties of disclosure. In this video, we shall cover the following. First, we shall look at, broadly, the arbitrator's duty of independence and impartiality. Second, we shall look at the arbitrator's duties of disclosure. Third, we shall look at conflicts of interest. And finally, we shall look at challenges to the arbitrator's appointment. So beginning first with the arbitrator's general duties of independence and impartiality. Now these duties of independence and impartiality are of utmost importance in order to receive a fair and untainted award. The importance of these principles can be seen, for example, in the fact that it has been adopted in a number of international documents, including, for example, the UNCITRAL, that is the United Nations Commission on International Trade Law's model law, as well as the International Chamber of Commerce's rules. It also sees applicability within the Indian context in the form of the Arbitration and Conciliation Act, where sections 12 and 13 bring in these duties, and they relate it to questions of conflict of interest and duties of disclosure, which we will now look at. So considering first the duty to disclose, now an arbitrator has certain duties of disclosure when any person approaches this arbitrator in connection to appointment in an arbitral proceeding. Now at this point, the duty of disclosure becomes incumbent on the arbitrator. When does the duty of disclosure apply? It applies in the following circumstances: where, for example, there is a relationship or interest between the arbitrator and the subject matter. Now, such relationship or interest may be a past interest or relationship or a present one. It could also be direct or indirect. Now, this interest or relationship may also be across various realms. It may be a financial interest, it may be related to business or profession, it may be some sort of familial connection, for example. Essentially, these are anything that can compromise an arbitrator's ability to be independent and impartial during the proceedings. Further, there is also a duty to disclose on the arbitrator, where the arbitrator is unable to devote sufficient time to the arbitral proceeding. So circumstances where the arbitrator will not be able to complete finalizing the award within the prescribed period of 12 months under the Arbitration Act is an instance where the arbitrator must disclose this fact. So these are the duties of disclosure. Now, helpfully, in the 5th schedule to the Arbitration and Conciliation Act, there are a list of examples that people can refer to when questioning what circumstances duties of disclosure would arise in. Now, some examples that have been listed in the 5th schedule are where an arbitrator has a familial connection with any person involved in the proceeding. For example, let's say the arbitrator is a cousin of someone in the proceeding. A second example is where the arbitrator was a client of any person involved in the proceedings, or vice versa. Yet another example is where an arbitrator has a financial interest. So let's say the arbitrator has shares in a company which is a party to the proceeding. Now, all these are examples of instances where the duty of disclosure is important and must be done. It should also be noted that this duty of disclosure is an absolute duty, which means in no circumstance can it be waived, even if the parties agree to waive and do away with this duty of disclosure. Now that we've looked at the duty of disclosure, we will now turn to questions of conflicts of interest. Now, conflicts of interest, unlike the duty of disclosure, render the arbitrator automatically ineligible to sit on the tribunal and deliberate the matter in dispute. Now, examples of conflicts of interest are similar to that where the duty of disclosure will arise. So some examples which have been listed in the 7th schedule to the Arbitration and Conciliation Act include, for instance, where the arbitrator is a lawyer in the same law firm which represents one of the parties. Yet another example is where, let's say, the arbitrator's law firm was previously associated with the case, even if the arbitrator himself or herself wasn't associated. So in these circumstances, there is a conflict of interest between the arbitrator and some part of the proceeding, whether it is one of the parties directly or the subject matter itself. Now, the difference between conflicts of interest and the duty to disclose is that, unlike the duty to disclose, a conflict of interest may simply be waived by the parties. Now, the parties must waive this expressly and they must do so in writing. However, with duty to disclose, on the other hand, the arbitrator cannot waive it and neither can the parties. So these are different in this respect. So what happens when there is such an instance where, perhaps due to a conflict of interest, an arbitrator is considered unsuitable to sit on the tribunal by either of the parties? In such cases, a party may challenge the appointment of the arbitrator. Now, when can the party challenge the appointment of the arbitrator? The threshold for this is essentially where there are circumstances, like we discussed above, which would give justifiable doubts that the arbitrator's independence or impartiality has been compromised. And further, a party may also challenge appointment if, for example, they believe that the arbitrator doesn't possess the requisite qualifications that is needed in the arbitral proceeding. How does a party then challenge the appointment of an arbitrator? Now, if the parties have agreed on a procedure previously for challenging the appointment, then they will utilize that procedure. However, if there isn't mutual agreement by the parties on how one must challenge the appointment of an arbitrator, then they may refer to the procedure set out in Section 13 of the Arbitration and Conciliation Act. Now, if a party is unsuccessful in challenging the appointment of an arbitrator, what happens then is that the arbitration simply continues. The recourse that this party may then have is to ask for the award to be set aside at a later stage. Well, that's all we have today on conflicts of interest and duties of disclosure. We hope you enjoyed this video. Thank you.